So I wanted to talk about the California executive branch officials and the revolving limitation that applies to them. Similar to the revolving door limitation on state legislators found in Article 4, Section 5E of our state constitution, executive branch officials of California state government are also subject to a revolving door limitation when these officials leave government service. And it's referred to as revolving door as the door between the public and private sectors of employment. So Article 5, which deals with the executive branch of the California state government, Section 14E provides that the legislature shall enact laws that prohibit a state officer or a secretary of an agency or director of a department appointed by the governor who is not resigned or retired from state service prior to January 1991 from lobbying for compensation as governed by the Political Reform Act of 1974 before the executive branch of state government for 12 months after leaving office. Now, this provision of the state constitution applies obviously to the elected constitutional officers. It prohibits state officers, as well as agency secretaries. Remember, these secretaries are appointees of the governor and serve as members of the governor's cabinet, and department directors who are also appointed by the governor. And all of those folks are confirmed by the California State Senate. Now, Article 5, Section 14F defines a state officer as the governor, lieutenant governor, attorney general, controller, insurance commissioner, secretary of state, superintendent of public instruction, treasurer, and the members of the State Board of Equalization. In addition, there are some statutory provisions that provide further guidance on the revolving door limitation affecting executive branch officials. Specifically, Government Code Title 9, Chapter 7, Article 4 concerns the disqualification of former officers and employees, and it begins with Section 87406, Subdivision A, which is otherwise known as the Milton Marks Post-Government Employment Restrictions Act of 1990. And similar to the provisions of the Milton Marks Act related to legislators, Government Code Section 87406 Subdivision C is applicable to the 9 elected state officers. And what it says is, an elected state officer, other than a member of the legislature, for a period of 1 year after leaving office, shall not for compensation act as an agent or attorney for or otherwise represent any other person by making any formal or informal appearance or by making any oral or written communication before any state administrative agency or any officer or employee thereof, if the appearance or communication is for the purpose of influencing administrative action or influencing any action or proceeding involving the issuance, amendment, awarding, or revocation of a permit, license, grant, or contract, or for the sale or purchase of goods or property. And for purposes of this subdivision, an appearance before a state administrative agency does not include an appearance in a court of law or before an administrative law judge or before the Workers' Compensation Appeals Board. Now, in addition, there's a similar prohibition that applies to certain employees of state agencies. And so Government Code Section 87406 Subdivision D1 provides that a designated employee of a state administrative agency, any officer, employee, or consultant of a state administrative agency who holds a position that entails the making or participation in the making of decisions that are foreseeably having a material effect on any financial interest, and a member of a state administrative agency for a period of 1 year after leaving office or employment shall not for compensation act as an agent or attorney for or otherwise represent any other person by making any formal or informal appearance or by making any oral or written communication before any state administrative agency, officer, or employee thereof for which the individual worked or represented during the 12 months prior to leaving office or employment. If the appearance or communication is made for the purpose of influencing administrative or legislative action or influencing any action or proceeding involving the issuance, amendment, awarding, or revocation of a permit, license, grant, or contract, or the sale or purchase of goods or property. And finally, this section says, for purposes of this paragraph, an appearance before a state administrative agency does not include an appearance in a court of law, before an administrative law judge, or before the Workers' Compensation Appeals Board. And this prohibition contained in this paragraph only applies to designated employees employed by a state agency on or after January of 1991. Finally, to note, elsewhere in California's Political Reform Act of 1974, and similar provisions are similar to provisions applicable to state legislators, there's also a ban on influencing prospective employers. In other words, a state executive branch officer or designated official is prohibited from making, participating in making, or influencing a governmental decision that directly relates to a prospective employer for that officer or official.